Now, first to limitation. As I said, I was going to some extent, pick up from where we left off on this subject in the 2008 updater. It doesn't matter if you haven't seen it. The points will become perfectly clear. But in 2008, I started with some discussion of a very controversial case about plural plaques, often referred to as Rothwell. The other title is Johnson and NEI International. And what the House of Lords decided there was that if you have plural plaques in your lungs, that in itself does not amount to damage. So the cause of action in tort is not complete. Of course, the cause of action in tort needs there to be some loss or injury. And the plural plaques can lead to illness, and they can be very frightening because people know they can lead to illness, but until that illness eventuates, there is no complete cause of action. And this was a very controversial decision. For one thing, if you scratch your skin, then clearly there is real damage. So the cause of potentially, if your skin is scratched by someone else's negligence and there was causation, then you have a complete cause of action in tort. Plural plaques in the lungs, there's some actual lesion in the lungs with no symptoms apart from what the doctors can pick up on their x-rays and so on. Why should that be different? Another reason it was controversial is that for 20 years or so, people had been recovering compensation for just this condition. And suddenly the House of Lords, when the insurance industry challenged in this, what was effectively a test case, suddenly the House of Lords said this was wrong, and so effectively the compensation stopped. Another reason it's controversial is that, of course, it's very frightening for people, and some of the claimants in that particular case, which we discussed, had a lot of them were frightened. Some of them, one or two of them, had become psychiatrically ill as a consequence of the fear. They become depressed, and they still couldn't claim because the court decided that a person of reasonable fortitude, in the jargon, would not become mentally ill as a consequence of this admittedly frightening condition. I'm going to say a little bit now about ex terpi causa or ex terpi causa, how you pronounce it, cases, because these have also come up, and it's a question of picking up a small thread which I left in the 2008 updater. A couple of cases have come up on this rather interesting point. One was Gray and Thames trains, which I discussed in 2008, and at that time it had not reached the House of Lords. In Gray and Thames trains, Mr. Gray was in a rail crash and he suffered minor physical injury, but he also suffered personality change and ended up committing manslaughter, which he would not have committed but for the personality change caused by the rail crash. And he sought to claim against the railway company, and the railway company raised a defence of ex terpi causa. In other words, if you go and commit a crime, you can't then go and claim for the consequences of the crime. And he sought to claim on several grounds for loss of earnings because he was in prison, or rather in a mental health facility, as a consequence of his conviction for manslaughter on grounds of diminished responsibility. Now that case, since we talked about it in 2008, that case came before the House of Lords, and the House of Lords upheld Thames Trains' appeal and firmly rejected the Court of Appeal's suggestion that the law should be changed to allow Mr. Gray to succeed in his claim. It also reversed the Court of Appeal's small decision in his favour that he could claim for loss of earnings while in detention. I want to say something about the work equipment regulations, which are also important in practice. So we'll leave the question of ex terpi causa there. Work equipment regulations, which are the interpretation of a European Union directive give a lot of trouble, because if work equipment is faulty and as a consequence somebody is injured, the employer is under strict liability. The question that the courts have struggled with is what exactly counts as work equipment, and I don't have any clear answers. I'm just going to point to some cases where the courts have wrestled with this problem and given somewhat inconsistent answers. The first is a case which came out just after the 2008 update, which I did last year. It's called Spencer Franks and Kellogg Brown. There was a man called in to an oil platform to work on a door closer which was faulty, and he tried to take the door closer off. It snapped back in his face and broke his teeth. And the question was, is the door closer on the oil platform equipment at work? And their lordships unanimously decided that the door closer was work equipment. But each of them delivered a judgment, and because they were overruling a strong court of appeal in another case, Hammond and the Commissioner of Police for the Metropolis, which I need to mention. In that case, a police mechanic had been working on a police vehicle, and in this case, because the vehicle wasn't provided for the mechanic's work, the Court of Appeal decided it was not work equipment. And the House of Lords said in that case the Court of Appeal was wrong, because the vehicle was provided by the same body, albeit not the same legal entity, in other words, police, as employed the mechanic. And this was the basis on which it was equipment supplied for work. And so in the case of the door closer, it was decided that the oil platform owner or operator was liable on that basis. It didn't have to be decided whether the contractor who employed the repairman was also liable. But there's some discussion, and this is the key point in this case, overruling the Hammond case, that the equipment was provided by the same entity that was employing the workman.